Welcome to the Family Law Channel. My guest is retired Superior Court Judge in Santa Clara, California, Eugene M. Hyman. Judge Hyman, welcome back.
Thank you.
All right, today we're going to be talking about a judge's criminal plea powers and specifically at issue felonies and the option to strike a strike. Judge Hyman, can you explain this a little bit?
All right, thank you. This was a case at the trial court level where during a settlement discussions, a Superior Court judge offered to give a defendant 5 years for a number of crimes and allegations. What the defendant had to do was to plead guilty to everything that was alleged, since the judge did not have discretion to change charges, since charging is the purview of the executive branch, in other words, the prosecutor's office. The prosecutor, after sentencing, appealed the judge's decision on abuse of discretion, saying that the trial judge did not have the authority to engage in plea bargaining, whereby the judge offered, for purposes of that case, to basically dismiss a strike, also known as striking a strike, for purposes of that case. The appellate court said that a judge only has the discretion to remove a strike or to strike a strike at time of sentencing, which is different than offering it. It is an inducement for a defendant to enter a plea. The defendant's attorney argued that it was a violation of equal protection that the prosecutor was the only one that could strike a strike up front, that the court should, as an equal participant in the criminal justice system, that the court should be able to have an opportunity to strike a strike as well. And the appellate court said that no, under case law, that belonged purely to the prosecutor at that stage, that the judge's opportunity to remove a strike or strike a strike, if that were to happen, would happen only at sentencing, and the judge could not make that promise up front.
And you feel that it's probably a better idea to give judges more criminal plea powers in general?
Yes, but also it's an equal protection. Why should the prosecutor be the only one that's able to make that offer up front? The Supreme Court, in the decision that gave judges the opportunity to remove a strike at sentencing, said that the proposition which enacted 3 strikes in California could not give that power purely to the prosecutors. And at that time, they said that a judge could strike a strike at time of sentencing, which was not discussed by that case, is whether or not the judge could do so in order to induce a plea. And that's the issue that the appellate court decided, and in my opinion, that needs to go before the California Supreme Court for resolution, whether or not, for purposes of equal protection, whether a judge at a plea stage should have that power.
All right, great job, Judge. Thank you.
Thank you.
You're watching the Family Law Channel here on the Legal Broadcast Network.